I call the Honourable Heather Roy.
Thank you, Mr Chair. It gives me great pleasure to rise and speak to Part 1, and I'd like to concentrate on two clauses as part of this bill, Mr Speaker. The first is the outline of the Act in Clause 3 in particular, and I think this is also relevant to Clause 7, the definition of marine and coastal area. Under this bill, Mr Chair, the assumption is that iwi and hapu have customary rights over all the common marine and coastal area. And of course this is the new terminology for what we previously in the bill that was debated under the previous government, the foreshore and seabed, unless the Crown can prove otherwise. So iwi and hapu have customary rights over all common marine and coast area unless the Crown can prove otherwise. And one of the things that ACT, through all iterations of this debate since the 2004 bill, Mr Speaker, has talked about, is everybody who feels they have genuine ownership bid should be able to have their day in court, so that's relevant there. Also, the bill contends that iwi have guardianship ahead of all others. To my mind, Mr Chair, the crux of the matter relates to property rights. And there were a number of submissions to the Select Committee that talked about property rights, and that's always the yardstick that I use, Mr Chair, when we think about how we proceed, how law is put in place, how we deal with things, particularly before the courts, and when the courts should be the decider, if you like, of who has genuine ownership. I think there are a number of things, and I'm probably going to run out of time in this particular call, Mr Chair, to talk about property rights, but there are a number of issues that should be considered when we look at the detail of this bill. I think that the bill is being justified to Pākehā and the public, generally speaking, largely on the basis that what will happen to the coastline in the future. Now, of course, there are large areas of coast that should be protected from development and exploitation. I don't think that there would be any dissension at all in this House from that view. Reserve status is justified for it, for example, but we shouldn't forget that we have one of the largest coastlines in the world, and alongside that, one of the lowest population densities and a declining economic capacity to maintain first world health, education and infrastructure. And so, as Stephen Franks submitted at Select Committee, he said he deplored the absence of any proper defence of genuine property interests in coastal areas, and I have to say on that point I agree with him. The bill, and some would say covertly, creates a form of exploitation right for some iwi and hapu. Now, those rights in areas in which they get marine titles can easily be supported, but the circumstances of creation of those titles could simply discredit any kind of status other than reserve. They don't give their owners the true owner's stake in preserving the long-term value of their interests, and that, Mr Chair, is something that I think we in this House should be genuinely concerned about, and I welcome the debate that we're having today in respect of that. I think that the bill is actually promoted without any proper defence of true property interests for Maori, and that might well surprise many of those on the opposition ranks hearing me talking about that. But what the bill does is it removes such interests from local authorities and even from current lease or licence holders. The bill should have been, I would have thought, for a national government, an opportunity to strengthen true property rights for everybody, all citizens of this country, whether they be Maori or whether they be non-Maori. We should, I think, also consider as a general part of this debate that property rights protect, or why we have property rights, why it's important, why it's a fundamental grounding of our legal system and what we stand for. Property rights, Mr Chair, protect minorities against majorities, so that those who have the money, the wealth, those who have the ability for whatever reason to wield a big stick aren't able to do so to the detriment of those who have a genuine property right. Mr Speaker? Mr Speaker? Mr Speaker?
The Honourable Perakura Horomia.
Give me another go.
E tua te tēnei te kai whakahaere o te whare, hei koro atu ngō te ahu o te pire nei. E toko tia tu ngā whakaro o puta awaha te toko hoa nei a Rawiri Pāka me Shane Jones. E whakaro atu mo te ahua o te tikanga mo te Takutai Moana, e puta atu te whakaro e waiho atu mo te minita nake, engari e whakaro atu rā tātou mo te haringa ki te kōti. No reira, te kai whakahaere, e nui atu ngā whakaro mo te wāhi tahi nei, e tūkaha atu e puta atu te whakaro mo te ahu o te tikanga, me te ture, me te waiho tiatu ngā tupuna kia tātou mo tātou nai Māori. Nā te mei i roti a te tuhinga, ki atu e tahi waiho tiatu ki ngā kōti. Nā te mea rochi a tātou e moheu, i reira ke we tahi o ngā iwi mai rāno e mau tatana ki te Takutai Moana. E ora ana te manakia ngā hua o Tangaro, e nui atu tā hua pērā tunu. E whakaaro atu hahai e ki tēnei anō te āhua nake e mau ana mo tēnei tino take. Nō reira, te kai whakahaere o te whare nei, e whakaaro atu mo ngā neke haere mo te ture nei. E timata atu te koro e puta awaha te minita nei, mo tōna whakaaro mo te whakaia, te kore whakaia mo te ture nei. Nā te tuhinga nei, e wehe atu mo ngā whakaaro a wetahi e pirangi, e waiho atu ki te minita e whakaia, kāre e tai atu ki ngā kōti, kāre e tai atu i roto nei o te whare miere. No reira, te rano te mea i rochi a tātou. I konei e wero ana mo tēnei wā. Nā te mate hoki pēra tonu atu te āhua mo wetahi o rātou e tai atu i te kōti, e mau atu te mātou ranga mo ngā kai whakahaere o te kōti i rochi a te ture. Te ture.
Sorry to interrupt the Honourable Member. The time has come for me to leave the chair. This debate is interrupted. I shall resume the chair at 7:30.